Good afternoon, ladies and gentlemen. It's a privilege and an honor to be present here this afternoon and thank the organizers of Courtroom and the ICF for inviting me to present this session. I promised to finish off my slides within 15 minutes and I have to skip some of them. Yes, I have a financial interest. I have attached to FX as a medical legal expert and also with Indian Register Quality Systems as ISO audit expert for Indian, for ophthalmic industry expert. So this is the panel of the consultants, pan-India for the ICF as medical legal experts, and I can be seen up here in the third position. And that's the sign of the Supreme Court of India. And this presentation was also given at All India Ophthalmic Society Conference last March in Kolkata. So what is GLOS? What is CPA? CPA is Consumer Protection Act, replacing COBRA. MLC is medical legal case. Plaintiff is a complainant who lodges complaint to the court. OP is the opposite party here, the doctors. Summon is an order to attend the court. Rest subsidies is litigation everything judgment. And contributory negligence is patient when lost to follow or refusing treatment that goes in favor of the doctor. And recently, IBC has been converted to Bharatiya Nyaya Samhita and Bharatiya Shuramka Samhita from 1st July 2024. Why I have highlighted it in red, I'm going to explain it in my later slides. So, that is my experience with law. I'm not going into details, only that I've defended my organization, Dr. Mukherjee Child Foundation, twice at the State Medical Council, once at the National Medical Commission, and also at West Bengal Clinical Research and Regulatory Commission. And I also own a injectable suit in the civil court. I'm experienced in facing cross-examination in the court, and by God's grace, I have not been defeated in any case which I have defended so far. So, court and doctor. A doctor can be summoned in the court as to give expert opinion, to give witness as evidence, and also the defendant in consumer court with advocate. In WBCRC, you are not allowed to enter with an advocate, you have to face it yourself. Summons must be obeyed. If disobeyed, civil case you have to pay compensation, in criminal case, fine or imprisonment you have to give. So, what is a medical legal case? A case of injury, illness, where the attending doctor, after eliciting history, finds that something else has to be done. Investigations should be done by law agencies. So, in order to do that, he fixes up that case as a medical legal case. So, common medical legal cases are traffic accidents, we all know, poisoning cases, gunshot injuries, drowning, domestic violence, case of assault, sexual assault, suspicious mode of injury, unconscious after suspicious circumstances, major industrial accidents, death on the operation table. This is a very, very sensitive issue. Death on the OP table, broad death cases. As far as NIH is concerned, they say that emergency register must be maintained by all hospitals, also for eye hospitals. And all hospitals must provide basic emergency medical aid. This is a Supreme Court order. I'm skipping this slide only to see the fact that death in OT and death after injection, this is applicable for all the other faculties of medicine. So, medical negligence is a breach of duty owned by a doctor towards a patient to exercise a reasonable degree of care and skill. That is the only thing that the court looks after. Please, ladies and gentlemen, to whether the doctor or the hospital has exercised reasonable degree of skill or care or not, and whether there was any physical, mental, and financial disability or losses. Hence, it is a civil or criminal mistake arising out of contract. This is a contract between doctor and patient relationship. And I tell you that all these slides are not AI generated, but it has come from all the rigorous lawsuits that I have faced and my own experiences in law. So, common allegations which are brought against doctors and hospitals are first we see in the newspapers, it is delaying treatment, refusal to admit the patients, improper investigation, failure to refer in time, failure to seek second opinion in time, failure to inform or take informed consent, failure to anticipate, detect, manage complications, non-availability of doctor when needed most, negligence in blood transfusion, and to check medicine expiry date, condition of IV fluids. Factors responsible for growing litigation against doctors, 5.2 million cases. Cases are getting filed against doctors and hospitals at the drop of the hat. Awareness of consumer rights increase, implementation of CPA, patient relatives are misguided by their agencies and media who are misguiding patients and relatives. Violence against doctors, which encourages others to follow. Poor communication skill and record keeping. Unethical and greedy attitude of some doctors. And unfortunately, criticism of another doctor in front of patients. We must stop this. When a criminal case occurs against a doctor, sudden death after an injection shock, death in OP, as I mentioned, abortion cases, PNDT cases, NTP cases, disabilities happening like gangrene, and death after delivery is less serious. You will be surprised to know that a doctor is answerable to all these cases. In all the commissions, district, state, central, in all the court of law, district, state, central, West Bengal Clinical Establishment Delivery Commission, NMC, as I said, social media, press, print and electronic media, police, and Sorashari Mukherjee. This is the phone number. Sorashari Mukherjee, anybody can lodge a complaint against a doctor. It goes to the Special Secretary Health. So, what is the concept? This was there in the flyer, so I'm telling this. There are basically 4 types of concept. When the patient enters the chamber, it is the implied concept. He has come for examination. Nothing written has to be taken. Express concept. After examination, you are the gynecologist, you want to do a PV. You will tell the patient I have to do a PV. Or you are neurosurgeon, or maybe a general surgeon, you want to do a PR, you have to tell the patient that we are PR for you. Similarly, for breast examination of any function. Informed consent, this is what we are all concerned of. It has to be bilingual, in Bengali or English, or Hindi or English. Written for special procedures related to diagnosis, treatment itself involves in certain physiological treatment. What are the costs? What are the benefits of this treatment? This is basically for surgery. Recovery chances, avoid medical jargon, layman words will be used, and qualified consent. This is very tricky. A patient or a party can say, I won't allow this, I only allow this much of treatment, not more than that. For example, somebody having multiple fibroid in the uterus, the patient party can say, please don't do hysterectomy, please do myectomy and come on. So the doctor can take up the case or also can say, no, I can't take up the case because I am not providing full treatment. Invalid, when the consent is invalid. Consent given by a minor patient mentally not stable, under the influence of drugs. If the patient is the consent is obtained with force, obtained for illegal, unethical purpose, obtained crudely. Consent not applicable. When consent is not applicable? When there is immigrant examination, magistrate's order to examine for notifiable disease, psychiatric examination, court order, examination of food handlers or harmful as per their service rule, examination of accused under arrest on requisition of police authorities. This question was asked by me in various conferences, whether a doctor can refuse a treatment. Yes, a doctor can refuse treatment. This is as per NMC registered Medical Practitioners Provisional Conduct Regulations 2023. If the patient is unruly or misbehaving or violent, the doctor can say, I won't treat you. But in that case, it has to be taken to record. Whatever the doctor has done, what is the incident that has happened, whether the patient has been referred to a higher center, and whether the doctor is reported to higher authorities in case he is practicing in a hospital. But the doctor can surely refuse a patient for treatment. Doctors don't need death declaration. This was there in the flag. So never use technical jargons. A pulmonary embolism, no. Make it simple. Talk with the patient party, 1 or 2 rules is applicable, particularly जाके आपने आगे brief correction patient के health दिए. That is important. A production of a flat line ECG sometimes it helps convince. Shows sympathy. Avoid using words like fast and late test on this good it can cause confusion. Say death. And issue of knowledge DC after 1 hour. It is no more 4 hours, please. It is 1 hour now. Regulation has been passed in 2006. That is the medical council. At one time of the cases, they were white. Because eye donation, cornea preservation in a place where there is no cornea bag, it has to be done within 6 hours. So a DC has to be given within 1 hour. Doctors would engage in a medical legal case. Immediately inform police, transfer the body to mortuary, hand over the body to police, never to the patient party or patient for autopsy. Request police to do a PN examination. Since the cause of death is not known, notice has to be given. Documents and records. Clinical, scientific, administrative, legal. These are our documents related to patient's care. What is a good medical record? It has to be complete, adequate, accurate, attributable, legible, original, contemporaneous. What is contemporaneous? Patient bhorti hocche dupur 12টায় আপনি this case is বিকেল 4টে, not that. In the court of law, it has to be at par with time. And deficiencies, incomplete consent, not signed, disappearance of records of manipulation, this is the deficiency of documents. Documentation is very, very important and running into it. Now, this objection is going on in more or less all medical fraternities after this NASH has been implemented. Previously, it was section 24A IPC. Imprisonment for up to 2 years or fine or both. Now it is and. Imprisonment and fine. So this objection has been raised by INA and other medical faculties to the Sarvaswati and the Health Home Minister to change this. So now, how to face the court? The more you sweat in peace, the less you believe in war. Good documentation is good records, is good defense. Documentation nothing is I have done this case. No value. You have to document it, show it to the court. Judiciary goes by hardcore evidence and factual details and not by emotion or sentiment. Please know this. It has been how to face the court? Preparation. Good documents is good defense. Execution along with your legal advisor and from that is from you can take. Break the myth. This is the myth that goes on in the mind of the doctors. Ami prochur taka premium di, the law needs to be take care. No sir. No way. A lawyer, it's not possible for a lawyer to understand medicine. Just like we don't understand law. You have to prepare your own brief in a case. Break the myth. You have to highlight the points. Judgment will be based on your reply. This is an important thing. You have to copy the question and give the reply. Judge doesn't have any time to modulate. You have to copy the question raised by the plaintiff and you have to give the reply on against it. This is most important, ladies and gentlemen. I have been saying this in all conferences, this was presented in 4 other conferences before. Never waive off your bills, professional fees, court becomes suspicious. Now the question can arise. Certain misfortune has happened, patient party is angry. How can I ask the patient to give payment for a second operation? What happens is that ideally you have to ask the patient party, a second time operation has to be done. This is the bill. Certain percentage of patients will pay. Some will say no. Already there's something problematic has happened. We are angry with the doctor, we are angry with the hospital, we won't pay. Then ask the patient party, write why you are not paying. Again, certain percentage will give it in writing. Some will say no. Then what to do? Ask your finance manager to generate a bill and stamp and sign that payment was not made. Keep it in records, place it in the court of law. Second operation in partial আমি wake up করে দিচ্ছি. Court becomes suspicious. Just 5 minutes. Court becomes suspicious. Never perform a procedure without consent. Never allow finance to control your medical decisions. These are the defense sections. No, this is for the, why I am written this. This is for the advocates. These are the sections in favor of the doctor. This is a famous judgment in the favor of the doctor. This is also Honorable Justice Martendo Karju judgment. There is a wrong notion going on in the WhatsApp and various doctors forum that after introduction of this Bharatiya Nyaya Samhita, all these previous judgments and IPCs are null and void. No, all are applicable. All are applicable, but the numbers have changed, but you can always quote the previous judgment which have gone in favor of the doctors. I'm sorry for the break, but the last thing is most important. These are the things in favor of the doctor. When there's a wrong or defamatory news posting against a doctor or hospital in newspaper or social media, we have this. Google against the hospital against you. So you can always take help. It's a defamation suit under 356(1)(2) to your professional indemnity company. So how to face the court? Evaluate, let it like completely your advocate and say, first reply to the plaintiff's allegation is to be rock solid. For hospital practice, always make an internal inquiry committee at least of 3 members, 2 doctors and 1 from administration. How to face the court, again, swap culture reports on a surgical case has to be produced. A job is not done unless it is documented, I have said. Never override or tamper your documents. And Bolan stays. Submit enough textbook, journal, internet documents in your favor to the court of law as evidence. Wikipedia is not accepted. And search whether they have tampered any document or not. That becomes contributory negligence. Never answer phone calls, text messages when lawsuit has been filed against you. That can be produced as evidence. Avoid out of the court settlement. Never use any harsh words or abusive language as it might go, as it can be recorded. Execution, when you are called in the court, your attire has to be formal, always stand up during entry and exit of honorable judge, never sit cross-legged. My lord and your lordship is for the advocates. Namaste, sir, madam, we can also do that. In witness box, no permission for taking oath, and don't be nervous. Always listen to the question and then answer as per the records. Be brief and to the point. And if any particular answer is not no, say that from available records I cannot answer. After a deposition, a type statement will be given, you can cross-check and sign. Show respect to the court before leaving, and you have got right DNDA with your expectedness. What is the judge's point of view? Did the doctor fulfill his or her duty? Did the doctor provide a standard care? Was the incident foreseeable given the nature of the incident training of the doctor? Did the incident cause the patient harm? And did the harm cause financial damages to the patient? So how to face WBCRC? More or less said, but here the advocate is not allowed. How to avoid legal hassles? You must know your job. You must see the first course of patient within 24 hours. Don't take decision on behalf of the patient. Inform and educate the patient. Never forget to take appropriate consent. Maintain records. I'm saying this all along. Maintain records. Emergency records has to be lifelong. Have provision in the legal insurance cover. Follow code of conduct and legal ethics. So the last line, take home message. Never take a complaint personally. I don't after I say complaint laws becomes nervous and emotional. Accept it as a war. Prepare your defense by consulting books, journals, internet. Always keep good rapport with your colleagues. Maintain emergency register. Always provide first aid. Owners lies on the plaintiff to prove that you are negligent. Remember, complication and negligence is not the same. Admit complication. Always say yes, complication has been admitted. But always defend negligence. And the last quotation, I have seen old pilots, I have seen bold pilots, but I've never seen a bold pilot getting old. Play safe within your jurisdiction. Okay? Thank you, ladies and gentlemen.